Thank you for joining us today. We are very honored to have with us today Jeffrey Amato, who is a partner with Winston Strawn, which is a law firm in New York and I believe nationally and internationally. And you do a lot of work with large antitrust cases and complex commercial litigation cases. So you have a lot of experience working with interpreters and translators. And
Yes.
well, thank you for joining us. So I wanted to open up with the question on what are the biggest challenges and issues that you have experienced working with an interpreter or having a need for translator in any large scale case?
Well, first, I want to thank you for inviting me, and thank you for the work you do providing interpreters and interpretation services, which really is indispensable to our job as lawyers in an international practice where we have many foreign clients, both from large companies that are overseas and also individual clients, whether they be of the employees of those foreign clients, or we also have a large pro bono practice where we help individuals from foreign backgrounds who do not speak English. And some of the biggest issues I've encountered working with interpreters is, of course, I'd start with quality. Some interpreters want to summarize the interpretation rather than taking extensive notes and interpreting as close as possible to the words that the attorney or the witness have said. And there are situations where it is absolutely not okay for the main interpreter to do this, like, for instance, in sworn testimony. It is okay in certain situations to not have a precise translation, such as when you're prepping a witness or giving informal consultation or learning facts, that you don't need an exact precise translation. But that's one of the main factors, of course, that we look for is really having that precision. And a problem for us is that we have an inability to recognize when that's happening because we don't speak the foreign language. And what we try to do here at Winston & Strawn to mitigate against that is, as often as possible, we try to work with our own foreign legal advisors or in-house clients that speak the native language and are familiar with the legal concepts and both languages, so that they know when the interpreter is doing a good job for a particular translation. I've also, go ahead.
So, but so we are not going to look at that from the position, from the position of the industry standards, because there are federal court certified interpreters. There is a lot of court certified interpreters that exist in this country, and a lot of people who adhere to professional standards and work. But what I'm hearing is, from the perspective of the end user, from the perspective of a partner in a very large law firm, this is the challenge that you're experiencing when you work with interpreters. So not everybody is trained. So definitely a lack for training on behalf of the interpreting profession.
Certainly, and it's a very difficult job to interpret a deposition, for example, with sworn testimony and have it be precise, and especially for languages that are not so common or not where certifications or court certifications are not available. For example, Japanese, which is a language we've worked with extensively at Winston & Strawn. There's really no court certification for that language. And so you need to really do good due diligence in working with those types of interpreters to find the good ones. And the language is difficult to interpret into English, which poses part of the challenge. And so you'll have a varying degree of competence in the interpreters that are available in the field. And so you want to be, depending on the situation you're in, you're going to want to make sure you have the best available at your disposal for the project that you're undertaking. And what I've found is that the competency level varies upon the circumstances in which you need the interpreter for. So, for example, in a witness prep situation, you may not be looking for precision and accuracy of the interpretation so much as an interpreter who's experienced in maybe the cultural or legal issues involved, where misunderstandings in the language can be worked out between the witness and the attorney, and the correct formulation of the language on both sides can be utilized so that there's no misunderstanding between the attorney and the client.
What about in a setting where you're in the court and you're working with a defendant who doesn't speak English and you have the jury? Have you noticed any challenge for that defendant being able to build some kind of a rapport with the jury when working through an interpreter? What are the challenges there that are not normally present when your defendant speaks the language? What are their additional challenges in those type of settings?
Sure, that's one of the biggest challenges in representing foreign clients is that there's first there's an inability for the jury to connect with the witness, and so you rely on the interpreter to try and establish a good rapport with the jury in tandem with the witness. And so that's an additional consideration when selecting an interpreter that the court would approve to be giving the sworn testimony for the witness in English. That's certainly one of the challenges that we face when working with foreign clients.
And in those type of settings, do you recommend having one interpreter in the courtroom, or do you recommend both sides having their own interpreters in the courtroom and an interpreter representing one side and the other side of the courtroom setting? What do you think is best?
Well, what I think would be most advantageous for my client would be a system where the court would have a designated interpreter, and then each side would have, if they would like, check interpreters who can interpose objections to the translation that is given to the jury, and then the main interpreter would resolve that objection between the two conflicting interpretations, and then present the final version to the jury. And that's similar to what happens in a deposition, mm-hmm. where each side would bring or could bring a check interpreter that can object to the main interpreter's interpretation of the witness's testimony. However, in that situation, you don't have to rule on the objection at that time, because it's a deposition, and you can have further litigation over which is the correct interpretation at a later point in time from maybe a neutral interpreter.
So what are the things that you would recommend for other attorneys or for the courts or for anybody working in the legal profession to consider when hiring an interpreter?
So when we're faced with complex litigation of large scale, when the need for interpreters is going to come up, what we've always recommended is to put in place protocols between the parties and the court that can be established to protect against the problems that will likely arise. So we usually enter into a deposition protocol whereby it's designated how objections will be made, whether they'll be translated, how much time will be needed for interpreted testimony as opposed to that's just in English language. We also recommend a translation protocol covering written translations of documents and how objections to those conflicting translations would be resolved. We also strongly recommend that the parties work together to come up with a list of interpreters that both sides agree are acceptable. And that really avoids problems in depositions where you have one party who doesn't trust the main interpreter that the other side may have brought to do the interpretation, or where really have a problem with the other side's check interpreter interposing objections that aren't really made in good faith. So what we've done is come up with lists of interpreters that we've worked with in the past on both sides, and that's the pool of interpreters that everyone would select from.
Interesting. So it's almost like you have within your setting your own, there's a court licensed interpreter, and then you have your own approved list that normally does not generate additional objections.
Exactly, because in most of the languages we've dealt with, there's no court certified interpreters available like there would be for Spanish, for example. I know there's court certified interpreters for that language, but I've worked with, when you're dealing with Russian or Japanese or other languages, you typically don't find that there's a court list of interpreters that are available.
So I would make an assumption that probably exists with many law firms and many jurisdictions in many situations. So for an interpreter, how do you make it on that list?
It's really word of mouth, I'd say. The lawyers speak to each other. It's reputation from dealing with the lawyers in various contexts of depositions and witness prep. And it's what I've found, it's a small universe of available interpreters for certain languages like Japanese. I've only worked with, a dozen or more in the many settings that I've had to use interpreters. And there's a go-to mix of them, and not just individuals, but services that provide for them, agencies that you can look to gather interpreters for the various tasks. And sometimes it depends on what country you're sitting in, who's available. So if you're doing witness prep in Japan, you have to decide whether you're going to pull from the pool of interpreters available in Japan, or you're going to bring your own interpreter from here in the US. And sometimes that's a strategic decision, because the interpreters in Japan generally are native Japanese speakers, and sometimes the interpreters here in the US are native English speakers, and they offer different translations because it's such a hard language to learn if as a second language.
Well, in many languages, the same concepts don't exist. You even have the same situation between UK English, British English, and American English, in all kinds of simple settings. So I think in the US, we say go to a primary care physician, and in the UK, we may say go to surgery, and, many other words where we don't understand even between English to English, right? So it's interesting different nuances that are there. But in building up on your last comment and working internationally, how has COVID impacted work with interpreters and the use of interpreters, and how has COVID possibly changed that?
Well, whenever I think of how it's changed or will change, I always think back to a story of when I was in a deposition pre-pandemic times, and in Japan, and the witness wore a mask during the deposition. And when we all sat around the table, I think we all looked at each other and said, well, can he do that, or should we say something? And out of respect for the witness, we didn't. We allowed him, all the parties allowed him to testify with his mask on. So I think about that situation, and then bring it into the COVID world, where if you're doing a in-person socially distanced deposition with masks on, there's actually been that could be problematic now that I've looked into it, because you want the facial expressions for both credibility, and for the interpreter, more difficult to interpret a witness where you can't see the person speaking. So those are two challenges if you're talking about a socially distanced in-person deposition. And then when you talk about virtually, I think there's pros and cons to it, because certainly anything done virtually is going to take more time, and working with interpreters is it adds another layer of time in any prep you're going to do with your client. So you have to factor more than just double or triple time in if you're going to do it virtually. And it's also harder to build a rapport with both your client and also the interpreter, which is important when you're working in an attorney-client relationship to really have the trust of both your client and the interpreter that they're providing a correct interpretation and that they're carrying out your ethical obligations towards the client in the appropriate way. But on the flip side, I'd say that working in the virtual setting, you're you cannot speak over one another, which is something that anyone who's worked with a foreign client and interpreters is something they're already familiar with. Or in a deposition, you have to respect the cadence of one person speaking, the interpreter providing the translation, the witness providing a response, waiting for the interpreter again to provide the translation. And I think that's what we've all learned in this virtual world is something you have to do because you can't really speak over each other on a virtual setting.
So kind of helped in a way.
In a way, I think it does.
Do you see any depositions in the future post-COVID happening virtually?
I do. I think that there have been many depositions taken place virtually, and people have become accustomed to it. And I think it's going to become more of a practice because traveling to Japan overseas to sit in the consulate where depositions are the only place where depositions can take place or within the U.S. consulate is going to be that process is very expensive. So it may be best to do it remotely if possible, either in Japan or from another location in Asia. Maybe
And
it's
are
better to stay here.
courts now more open to being able to accept that? Because I'm sure in the past there was what type of deposition the courts accept. So are the courts now more adaptable to accepting that moving post-COVID, you think?
Yeah, we've seen that courts are now moving towards virtual hearings, and some have even had virtual trials. And so, yeah, I think that they are now more open to having virtual live testimony, which I think the U.S. courts have lagged behind some other countries. I know I was involved in a witness testifying in the High Court of London maybe 6 or 7 years ago, and there was no problem with that happening. But in the U.S., there's a lot of restrictions on video and signals going into federal courtrooms, at least. So it's good that the courts are evolving here to work with this pandemic and then in the future.
That would be a very interesting possible subject of a whole other interview, working with remote jury and the dynamic of remote jury in courts. But wrapping up, I wanted to ask you, what advice would you leave the interpreters with? What can interpreters do better or different, given your experience?
Well, I think preparation for the case, learning the lingo of the case, the industry that's involved beforehand, maybe meeting with the attorneys to understand the issues involved, the meeting with perhaps meeting with the witness to have a session about unique names and official titles that may be unfamiliar beforehand, before the actual prep session or deposition. So preparation, I think, would be key in learning these concepts. And another thing would be to make sure that they take appropriate breaks when needed and don't burn out. I know it's a very exhausting process, and I've seen interpreters who are jet lagged and just gave up and had to take a break and give the interpretation over to the Czech interpreter. And that was unfortunate, because it's so difficult of a job to do. I've noticed that, and so that's another thing I would put on the list. And also just building trust and being amicable with the attorney and the witness in the room, and really being an extension of them both is an important part of that role.
Well, thank you. Thank you so much. And thank you for your time today. And we look forward to maybe having another conversation another time. Thank
Thank
you.
you so much. It's been a pleasure.